but I'll take one more.
Thank you,
Call the
Mr.
Honourable
Speaker.
David Parker.
Thank you, Mr. Speaker. Can I just deal with a couple of points that have been raised for a start by the Honourable Jerry Brownlee? He said, because the Part 1 debate was long, we shouldn't be able to recommit. Well, I heard you say that. I might have misunderstood what you said, but I thought you were saying that because there had been a long Part 1 debate, it should have been raised as part of that debate and we shouldn't go back. I think that is wrong, sir. There was a long Part 1 debate because this is a serious matter and there are lots of hooks in it. The second point I would make, sir, is this reference that we've had since that debate concluded that the Prime Minister can somehow fix this legislation in a third reading debate. That is a misapprehension of the relevance given to third reading debates by the courts. The courts only ever have regard to third reading debates in the event of ambiguity. They do it to cure ambiguity. They don't do it to rewrite the law. And in this case, it is clear that there is not ambiguity. It's that the Prime Minister wants to read this law in a way that it doesn't, in a different way to that which it naturally reads. Rubbish, says Jerry Brownlee. It's not. You said rubbish. Order. Okay, utter rubbish from the Leader of the House. The problem arises from the fact that the definitions in respect of what the GCSB can look at are so broad as to include the content of emails. That is the essential problem. It is not ambiguous. That's what the law says in this bill. The Prime Minister has, since we had the first reading, Part 1 debate in the committee stage, says he's not going to interpret it that way when he is called to grant warrants. He's going to...
I can understand. The Honourable Jerry Brownlee.
Well, you probably can anticipate what I'm going to say, but the Honourable David Parker is beginning to stray very, very wide of the motion. You were good enough to allow him to make a contribution to outline why he thinks the House should put more time into a part that it has previously decided upon, but to start arguing the merits of the decision, as he is now doing, is not appropriate inside Standing Order 1735.
Okay, speaking further to the point of order, Mr. Speaker.
The Honourable Member. Chris Hipkins.
Mr. Speaker, Speaker's Ruling 21 bar 2, of course, stresses that it is the right of a member to raise a point of order, but once a matter has been raised and has been ruled upon, it is disorderly to continually raise that matter. Mr. Brownlee's raised the matter of relevance in this debate. I've lost count how many times, and each time the matter has been ruled upon. Therefore, he must be getting into the area where he's becoming disorderly by continuing to interrupt members to question the relevance of it. The chair is the judge of relevance. There can be no doubt that Mr. Brownlee has a view of how the chair should be interpreting the relevance of this debate, and continuing to raise it with the chair is disorderly.
Thank you. Can I just advise members that it is a narrow debate. I've been generous in my calling, and I just caution members that we actually do need to debate this in the narrow way in which Speaker's rulings allow us to do so. I call the Honourable
Thank you,
Parker.
Mr. Speaker. Well, the point as to process, sir, is driven from the fact that a third reading speech cannot fix legislation that is flawed. A third reading speech can be, in very limited situations, that is why we need to recommit it. I'm afraid it is, Mr. Brownlee. That's exactly the point. We've heard the Prime Minister say he's going to fix this in a third reading speech. Third reading speeches can only be had regard to by the court in the case of ambiguity, and we're saying it's not ambiguity, it's something that needs to be fixed in Part 1. Sir, in terms of the Leader of the House's contribution that this was going to lead to a very long, open-ended recommittal to Part 1, the motion itself says that the reconsideration of Part 1 is limited to the consideration of this one supplementary order paper. It's not all supplementary order papers, it's not the whole of Part 1. This motion, if passed, would allow the House to recommit to committee stage for the purpose of considering, and I read, for the purpose of considering, and if it thinks fit, adopting the amendments in David Shearer's name set out in supplementary order paper 331, I think is as it's meant to be read, to prevent access to the content of New Zealanders' emails either unless absolutely necessary under Section 8A. So it's not, sir, an open-ended recommittal of Part 1. It is the committal of Part 1 for this very narrow consideration of this issue, which, since the committee finished its consideration of Part 1, has been raised as an issue by the Prime Minister through the media. Sir, we are dealing with civil liberties. We are dealing with the power of the state to intervene in the private lives of New Zealanders. It seems to me that this is a very appropriate case. This would be... I have read the bill, Mr Brownlee. I suggest I understand it at least as well as you, at least as well as Mr Brownlee. Mr Speaker, I'm going to end my contribution there because the other points have been well made. But this assertion by the Prime Minister that somehow a third reading speech can fix a flaw in the legislation is wrong.
Mr Speaker.
I call the honourable member Shane Ardern.
I move that the question be now put.
The question is that the question be now put. As many of that opinion will please say aye. Aye. To the contrary, no. No. The ayes have it. No. Party vote called for. Clerk, please conduct a party vote. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 opposed.
Māori Party.
3 votes in favour.
Mana. Act New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
Brendan Horan.
1 opposed.
Any other votes?
Honourable members, the ayes are 64, the noes are 56. The motion is agreed to. Thank you. The question now is that the motion be agreed to. Those of that opinion will please say aye. Aye. To the contrary, no. No. The noes have it. Party vote. Party vote call for, please.
New Zealand National.
59 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party.
14 in favour.
New Zealand First.
7 in favour.
Māori Party.
3 votes opposed.
Mana.
1 in favour.
Act New Zealand.
1 vote opposed.
United Future.
1 vote opposed.
Brendan Horan.
1 in favour.
Thank you. Honourable members, the ayes are 57, the noes are 64. It is not agreed to. I declare the House in committee for further consideration of the Government Communications Security Bureau and related legislation amendment bill. Mr Chairman.
Mr Speaker.